Hi everyone. I just wanted to add some stuff about originalism and interpretation of Constitution, which is, I think, in originalism it is very interesting. The problem with originalism is that, um, first let's just recap. Originalism is you interpret the Constitution within the context into which it was created. So you have to look what the fathers intended. What did they mean by freedom of speech or right to bear arms or cruel and unusual punishment? What did they mean at the time that the Constitution was created? Um, the problem with that is uh, there is no single interpretation, or there is no single and or exact idea what actually did they mean at that time when the Constitution was created. What it meant for the society that it which it was created. I just do not think that originalism. Um, it's a good idea the to study context into which things were created, but you cannot apply rules and look. Oh, what did Hamilton, Alexander Hamilton mean by, let's say Federalists, in a strong federal government, where that we have a state, and what it meant to Alexander Hamilton or in Federalist papers is totally different than what we have today. I think it is a good idea to look at the Constitution through history and how the meanings of, let's say, fundamental rights like freedom of speech, right to privacy, Fourth Amendment. For example, like criminal law in Miranda versus Arizona, when Warren Court in, I believe in 1630, in 1960s, Warren Court was, um, it became a little more liberal idea of interpretation, where interpretation of criminal law and how Constitution would apply to criminal law. So, for example, in Miranda versus Arizona, Miranda, who kidnapped uh, this person, kidnapped and raped and all that, he had many brushes with the law. Let's just put it that way. And when he was arrested, he asked the judge. He says, "How do I know what are my rights? How do I know what what are my rights when I'm being arrested?" So that case went all the way to Supreme Court, which is Miranda versus Arizona, and which presented the idea where Supreme Court decided in favor of Miranda, saying, well, every time a person is arrested, they should be told whether they have rights. So, for example, like you have a right to remain silent. Anything you say can and will be used against you in a court of law. Um, you have a right to an attorney. If you can afford one, we can provide you one. And they also have to ask you if you understand these rights. That the question with that case is that it changed. So if we are looking at the originalism, we can say, well, did Hamilton and founding fathers intended for for a person who's being arrested for his rights to be read to him or her? And maybe not, maybe they did, but and this is how the law it's changing and evolving. And you have a right to an attorney. That hasn't changed because that's guaranteed by Constitution. But Fifth Amendment right to remain silent, and things like that. Um, but it's changed. So it's certain laws may have had the meaning. The problem with originalism that I want to point out is that how do we know exactly what they meant or what they intended? There is no way of knowing exactly what Constitution meant when it was created. Yes, we have ideas. Yes, we have interpretations, but those are contextual interpretations because their set of beliefs and things that they believed, we have changed. The law has changed. The law has become more complex, more um, it's there's been many different interpretations of, for example, First Amendment. Um, if you have a, First Amendment, if we establish that you have a right to free speech, does that mean um, should we apply rational basis test? No, we shouldn't, because rational basis test is applied if you do not have the fundamental right. But strict scrutiny test is applied when you do have a fundamental right. Like if the freedom of speech is um, fundamental, which we believe it is, what it freedom of speech, freedom of press, freedom of religion meant in the times when it was created. While when Justice Holmes, he defined for what is a freedom of speech. He says, one should not shout fire in crowded theater, or clear and not. He didn't say that. It was actually different justice. Justice Holmes was the one that freedom of speech should not be allowed if it presents clear and present danger test. And that kind of elaborates further on shouting fire in a crowded theater. You do not have, because that creates an immediate danger to people if you shout fire, but there is no fire in the theater and you shout fire, you are not protected. You can be prosecuted for that because your speech is presenting an immediate harm and a danger to people around you. So this is more idea about originalism, uh, and in certain sense, I do support originalism, meaning we have to look how was Constitution created and all that stuff, but that should not be sole and the determining factor is to how to interpret today's law and to interpret today's society and developments that we have made. All right, we'll talk some more later.